Hello, my name is Aloys Hüttermann. I'm partner with Hüttermann in Düsseldorf, and you're listening to IP Fridays.
Hello, and welcome to this episode of IP Fridays. Our names are Ken Suzanne and Rolf Claessen, and this is the podcast dedicated to intellectual property. It does not matter where you are from, in-house or private practice, novice or expert. We will help you stay up to date with current topics in the fields of trademarks, patents, design and copyright, discover useful tools, and much more.
Welcome to episode 128 of IP Fridays. Today's interview guest is Aloys Hüttermann, who is partner and patent attorney with Hüttermann and partner in Düsseldorf. And we are talking about the UPC, the Unified Patent Court, and the Unitary Patent System and everything you need to know and what is coming in fall this year or early next year. Before we jump into this very interesting interview with Aloys, I have some news for you. The EU IPO has reached 2.5 million trademark applications. This comes shortly after a record 2021 with almost 200,000 trademark applications received by the EU IPO last year. But maybe more importantly, the recent developments in Ukraine and Russia are leading to some concerns among IP practitioners. Russia has issued a decree saying that damages of IP rights, so in lawsuits based on IP rights, cannot be recovered if the plaintiff is coming from a Western country. And there's a long list of Western countries that are part of this decree. So IP rights can no longer be easily enforced in Russia. That is at least my take. Also, it seems that the Rospat, so the Russian Patent Office, is no longer accepting payments from these Western countries that are on the list. So some IP owners need to find other ways to pay the fees for maintaining the IP rights in Russia. Also, it might be important to know that a lot of leading IP law firms have closed their offices in Russia. So now let's jump into the interview with Aloys Hüttermann. Today's interview guest is Aloys Hüttermann. If you don't know who Aloys is, he is partner with Hüttermann and partner in Düsseldorf, a leading patent law firm in Germany. And he is also author of a book about the new unified patent system, and also writing a new commentary about this Unified Patent Court and the Unitary Patent System. Thank you for being on the show, Aloys.
Thank you. It's an honor for being invited.
So do you want to extend my brief introduction a little bit by talking about first a little bit about yourself, where you come from, what you do?
Yes, of course. So my name is Aloys Hüttermann. I'm chemist by background. I have a PhD in organic chemistry, and after finishing that, I decided to become a patent attorney, and then I did the training for the German Patentanwalt. So I'm a classic German Patentanwalt, and shortly after I finished that, I co-founded Hüttermann and partner in 2006, and I'm with that firm ever since, and I hope that I will be there until I retire, which is hopefully not going to be, I'd say, too soon, but in a couple of years, maybe even a couple of decades to come.
All right. So today we are meeting because the Unitary Patent System or the Unified Patent Court is starting soon, later this year or early next year. Patent litigation, how it is today, will therefore fundamentally change with the start of the Unified Patent Court and the Unitary Patent. Can you briefly outline what the Unified Patent System is?
Well, briefly, it's not so easy because the system is very complex, but I can try. So the Unified Patent System is a new system of obtaining patents and also litigating it. And it consists of two parts, as you already mentioned. It's the unitary patent and the unified patent court. And the unitary patent is based on two EU regulations, which were already passed in 2012. The unified patent court is based on an international treaty, the agreement on the unified patent court, which soon will be eventually see the light of the day once Germany has deposited its ratification with the EU. Since the Unified Patent Court is based on an international treaty, this was one reason why it took so long, because international treaties, first they need to be agreed on, but then they need to be ratified by a certain number of countries. That depends on how it is laid down in the agreement. And then these countries do not only need to ratify, they also need to deposit their ratification somewhere. And the ratification process in Germany was first halted by a constitutional complaint, which was then allowed, at least partially, by our constitutional court. So we had to do another round of ratification. Well, then there were again complaints, but these were then dismissed. So now Germany has done their job. They have ratified everything, but they still need to deposit this ratification with the EU, because in the UPC agreement, it is laid down that the EU is the office where you need to deposit your ratifications. The reason why Germany has not done this yet is not political. So politically, this is all done. It's technical. And it's very easy. In the agreement itself, there are no transitional periods or something. So from day one, the UPC, the Unified Patent Court, which is abbreviated as UPC, I would do so also within this call, must be working. And I mean, if you file a suit somewhere, it's good that there is a judge who reads it, or maybe even more than one judge, or a couple of judges. So these have to be hired, but in order to do that, actually a second agreement was needed. This is called the Protocol on the Unified Patent Court on Provisional Application. I will not say that again. It's called the Protocol. Everybody calls it the Protocol. And this protocol had to be ratified too, but this has already happened in January this year. So now the UPC is officially founded, and it can now hire judges. So the interviews are going to be conducted in the next month. And then, depending on how well that goes, the UPC will inform Germany that they are close to start, and then Germany will lay down the ratification, and then the whole thing will come, finally.
Okay, so the timeline is not clear yet, but it's pretty clear that later this year or earlier next year, this system will start. So what will be the most important changes for patent owners?
Oh, well, there are many.
I mean, focus on the most important ones.
Yeah, I know. So, concerning on the patenting side, it is that patent owners will have a new option. And I should say that the way of obtaining patents is not changed. So you have the European Patent Office and you have the National Patent Office, and they remain as they are. But if you have a granted European patent, then instead of validating it one by one, country by country, then in the future you can choose a unitary patent. And this means, abbreviated, that you validate 17 countries in one row. Why 17? Because when the UPC system comes, 17 countries will have ratified the UPC agreement, and that also means that they are covered by the unitary patent. So if in the future more countries ratify the UPC agreement, then of course unitary patents, future unitary patents, that's important, will also extend to these countries. This is the easy one, because you can choose to do things as you are doing now. You don't have to choose the unitary patent. You can stick with the current validation system. The more complex and more important one is the litigation side. From day one of the UPC, at least in principle, it is so that the UPC is competent for all European patents, future ones, but also existing ones. So if you have a European patent, for instance, covering Germany, it is so that right now, if you see an infringement and you want to stop the infringer, you have to go to, I don't know, Landgericht Düsseldorf or Landgericht Mannheim. And in the future, you must go to local chamber Düsseldorf or local chamber Mannheim. The important thing is that you don't have to do that. You can decide that you want to stick with the system as it is now, but if you want that, then you have to do something, and this is called the opt-out. Technically, it is a request according to Article 83.3 UPCA. And what does that mean? It means that you file a request with the UPC that for a certain patent, you don't want the UPC to be competent, you want the national courts to be competent. And once you have done this, then you can still go to the national courts and, not unimportant, a third party who wants to attack your patent must do that as it is now, country by country in nullity suits. Of course, if there's still an opposition deadline pending, then you can file opposition. But once that is over and you have an opt-out filed, you have to go country by country.
So what would be a reason for patentees to opt out certain patents out of the new system? Would that be mainly a trust issue, or would that be, are there also other reasons why patentees should or would opt out of the new system?
In my opinion, it's basically a trust issue. But if you trust the UPC, still a reason to opt out could be that you think the UPC is too expensive. The thing is that at the UPC, like in Germany, you have a loser pays system, but we don't know how much the costs that you will have to pay will be. This is still ongoing. There is like a ceiling of costs depending on the value of dispute, but this ceiling is much, much higher than for a comparable case in Germany. So we don't know how this works out because this ceiling is not automatic. So the UPC can decide that the costs that you will get reimbursed if you win are going to be much lower. So we don't know yet. So this could be one factor if you otherwise fully trust the UPC to opt out. But the main reason would be trust. And another reason would be that you want to make life difficult for infringers. At the moment, if you cannot file an opposition, you have to file nullity country by country, whereas with the UPC, there is one central attack against a patent. So if you want to increase the hurdle for potential infringers or for competitors, then you could opt out. I should say something about the opt-out. So an opt-out is possible only if there's no action before the UPC. So if you file an infringement suit and then you find out, no, it's not working so well, then you cannot opt out anymore. But that's something you can decide. But also if a third party files a nullity action against your patent, then an opt-out is not possible either. So this has caused much concern, especially, I don't know, like 7-8 years ago, when the whole system was still a little bit under construction, because many observers then feared that for certain patents, there would be like a race to the courthouse. So the patent owner would be trying to have its patent opted out, whereas competitors would only wait for the UPC to start to put their nullity action on the table of the UPC, and then we have to see who comes first. In order to prevent that, it will be possible during the protocol phase to opt out a patent. You cannot do that now at the moment. It will be possible at a later point in time. We don't know yet. There are rumors that it will be possible once Germany has deposited its ratification, but that's, to be honest, pretty unclear.
But it is quite certain that it will be before the start of the UPC, so that the patent owners will have a chance to opt out the patents before anyone would have a chance to file a nullity suit, right?
Yes, exactly. So we will have a time period of, I don't know, 3 months probably, maybe 4 months, where you can already opt out. And then if this opt-out has been registered, it will then be automatically valid once the UPC comes. So the thing is that if you see that the UPC is actually doing not too bad, you can revert your opt-out once, you can opt in. And this would be another reason for patent owners that say, okay, we still wait a little and see how things go. And if they go well, then we can opt in. The thing is that, of course, if everybody opts out, then there are no cases. So this is a strategy that depends on that there are others who think otherwise. I should stress that the opt-out is possible for the first 7 years. Well, the first 6 years, 11 months. You have to file it 1 month before the 7-year period ends for any patent where there has not been an action yet. So you still have some time. But on the other hand, this opt-out period has an end. So in the not too distant future, it will be so that there are no opt-outs possible anymore. It is possible that this opt-out 7-year period is extended once for another 7 years, but I would think that this is pretty unrealistic that it will come, because either by then the UPC is accepted as the venue of choice, or it is not, and then people will rather discuss about how to get rid of the UPC than extending this extending this opt-out deadline for another 7 years. So the basic question is, do you trust the UPC? And if you say yes, then you don't need an opt-out. You can also ask yourself, do I need security? And if you need security, yes, then you should opt out or actually consider it. Another question will, of course, be how high is the chance that you get a nullity action against your patents, like out of the blue? So how high is the chance that you come into your office one early morning and then you find out, against the patent of mine, somebody has filed a nullity action, although we have not discussed about this patent with this competitor or with this party. So if the chance is reasonably high, then you could think that you need a safeguard, and then your willingness to opt out may be increased. If you are in an area where those nullity actions out of the blue are hardly ever seen, then you can maybe first wait and see what happens. And only if you see an infringer, then you can decide, okay, do you want to sue this infringer at the UPC, or do I rather want to go national again?
I mean, one of the advantages of the UPC is that you get pan-EU or a ruling, a decision covering many countries of the EU. And one other advantage of the UPC system is that it is very likely that the most experienced patent judges from the important patent litigation countries in Europe, such as Germany or France or Netherlands or Great Britain, not Great Britain anymore, of course, they left the EU, but the judges from these countries, they are very likely to join the new UPC system, right? Yes.
Well, I mean, of course, at the moment, interviews are being conducted. And of course, everything is secret. So officially, it's not clear who has applied with the UPC. But unofficially, it's clear that every German patent judge, well, except for those who are either close to retirement or don't like to work in English, because could be the case, that except for, I don't know, a handful of judges, all of them have applied with the UPC. So maybe not all of them will be hired, but quite a few. So it could be that in the future, before Düsseldorf Landgericht, there are judges you've never heard of before. And if we have bad luck, then they have never heard of patent law before. Whereas all the big names, all the experienced judges, I don't want to say any names, you all know them, they are with the UPC. And that could happen.
So that would be a good reason not to opt out your patents, because it could be the case that inexperienced judges in the national courts would decide on your patent infringement then.
Yeah, well, one has to say that there are plans that, except for a few, all of the judges will work part-time. The reason for this is that the UPC wants to have, let's say, a solid number of judges who are potentially available for working on cases, but on the other hand, they don't want to pay them all. So, and it is possible to be a part-time judge. Most of the judges may be part-time judges, at least in the early years. So it could be that still some of the household names are both at the Landgericht Düsseldorf or Mannheim or Munich or Hamburg, because that's the 4 locations where the UPC will operate in Germany, and half a part of the time at the local chambers. But it could be that if the UPC runs well, that, I don't know, in 1 or 2 or 3 years, then all of these judges will work at the UPC full time.
Right.
So it's I get asked that a lot. Should I opt out or not? And my answer is that's not easy to decide. There are many in-house counsels who have said publicly, but also in when you speak to them in private, that they will want to opt out, but also be part of the UPC. Because another reason why you should be involved in UPC is that the tracks are laid early. And the classic example is the European Patent Office. If you look at the decisions of the European Patent Office, the landmark ones, or the way of ruling, like the problem solution approach, the two-list principle, I've called it Hilbertian approach on novelty and amendments and priority, so which have led to this very strict ruling on how you can amend your patent. All of that is out of the first 2-3 years when at the EPO appeals were decided. So if you are not there to at least argue before the UPC, of course, you're not the judge if you're a patent owner, but it's at least you can bring forward argument. But if you don't do that, others will. And then in the end, you have to live with the results. Because in the end, in 10 years or so, you have to sue at the UPC. The only way to avoid the UPC would then be to file national patents. So in-house counsel have told me, look, we will opt out our crown jewels, our very important patents. And with the less important ones, we might try enforcing them at the UPC if there is an infringement. But this, of course, means that you have to take a look at your portfolio and decide which patents are important, which of them are crown jewels, and which of them are not. So it's a decision that needs to be made, let's say, very carefully and diligently. So you have to develop a strategy, what you want. And once you've done that, you can then decide whether you want to opt out or not.
Okay. I assume that the same arguments, opting out or not, are true for validating a patent with the new system or according to the old system, right?
Yes. I mean, the thing is that the unitary patent has one disadvantage is you cannot opt out. So if you are choosing a unitary patent, you are stuck with UPC. So if you don't trust the UPC, then you should not file a unitary patent. But if you at least say not distrust the UPC, and you could imagine that in a few years down the road, the UPC will do good, then you could think about validating your European patent as a unitary patent. But then, of course, the main factor is costs. So the defenders of the unitary patent say, look, you get 17 countries covered, but the annuities are only 4. And the validation is easy. You can do it at the EPO. You don't have to go with national attorneys. You don't need national representatives. You have a translation that you may file, but that's it. And the validation is cost-free. So it's pretty efficient. On the other hand, most patents, as we know from statistics, are being validated in Germany, France, and the UK only. And the UK is out. So the delta that you have to consider is how much are the costs of the unitary patent against Germany and France combined. And is this delta in costs, is that worth the extra coverage? And that's something you have to consider. And if I'm asked if there's a rule of thumb, then I usually say, consider whether you need Italy. In Italy, you have to file a translation into Italian. You need a national representative. So you have costs, initial costs, that you can avoid if you have a unitary patent. And if you need Italy, then a unitary patent might be a good choice. If you don't need Italy, then you could consider that you stay with the current validation regime.
Okay. So one other aspect is that the Unified Patent Court will, in practice, eventually replace the national courts with respect to patent litigation, or this is expected, and the revocation actions. When will this happen? Why does this happen? And what should the patent owners know about that?
For everything that the EPO grants, once the opt-out deadline is over, you are stuck with UPC. Only for patents that you have opted out before, those still stay with the national courts. If you then want the national courts to be involved and also a nullity country by country, then you have to file nationally, which means that you have to go to the German patent office for German patent, the French patent office for French patent. But here already the difficulty is that France has closed the national route. So if you want a French national patent, you cannot do this out of a PCT application. So I don't know if they will open that again, but at least at the moment, Paris Convention is your only choice if you want to claim a priority and get protection in France. So this is what you can do then. For a few years to come, we still have like a hybrid system where you can have your patent granted at the EPO, and if you have opted it out, you can still litigate it nationally. But in the long run, the UPC will be your venue if the EPO grants you something.
What about the national validation if you don't validate as a unitary patent, but as national patents?
That will not save you. So if you have a national validated European patent, you still have to go for the UPC. Of course, you can enforce it only in the countries where you validated it. But for litigation, you have to go with UPC. And also, if you're a competitor and this patent is not opted out, if you want to destroy it, you have to file a nullity action at the UPC, which could be a disadvantage for you should the UPC come out to be more patentee friendly than some national courts, which could, with some probability, be the case.
Okay, so that's also a very interesting point to know for patent owners. We have talked a long time now about the new UPC system. What are your three most important takeaways for our listeners that they should remember from this interview?
Well, The first is that big changes are coming. You should try to make yourself a picture about the unitary patent, and more important, about the UPC. The second one is you should make decisions about whether you want to opt out your existing patents. And you should do that pretty soon, because it could be that you come to the conclusion that you want this preemptive opt-out, and this will be then available in a few months from now. The third decision that has to be taken is, do I want unitary patents? And if you want unitary patents, then the EPO will help you. The EPO has recently published that once Germany has deposited its ratification, then for all pending application where you have a positive, let's say, feedback, a 71.3 communication, which is technically not an allowance, but it is an intention to grant. But you have not confirmed that by paying the fees and funding the translations. Then once you answer this communication, you can also request that the publication of grant is delayed until the UPC is in force, because only for European patents where the publication of grant is after the coming into force of the UPC, you can get unitary patents. So the EPO offers that as a service. And what you also can do is already register. So then you can already register preemptively as a unitary patent, which has the advantage that if you make a mistake there, then the EPO will contact you, and then you will have the ability to correct that. But this is all then done whilst the UPC is not yet enforced. So then you can be sure that you have a unitary patent once the system really comes. So these are the three takeaways. One, make yourself a picture of the UPC. B, decide whether you want an opt-out or not. C, decide whether you want a unitary patent or not.
Okay. Thank you very much for these three takeaways and for all the time that you have spent here. We were only able to barely scratch the surface of this very complicated and complex system, the new UPC system. If our listeners want to know more about you or the UPC system, where can they reach you best?
Well, they can reach me via email, of course. We have some information about the unitary patent system on our website. You can also take a look there. Well, at the moment, you cannot read any publications from me because my book is already sold out. And the second edition of that book and the commentary is still in preparation. So I think the best way would be that you look on our website, mhpatent.de, and see what you can find there.
Thank you very much for being on the show and spending time with me explaining what the UPC system is. Thank you so much, Aloys.
Thank you for having me. And I'm really looking forward for the UPC to come.
That's it for this episode. If you liked what you heard, please show us your love by visiting ipfridays.com/love and tweet a link to this show. We would be so grateful if you would do that. It would help us out to get the word out. Also, please subscribe to our podcast at ipfridays.com or on iTunes or Stitcher.com. If you have a question or want to be featured in one of the upcoming episodes, please send us your feedback at ipfridays.com/feedback. Also, please leave us a review on iTunes. You can go to ipfridays.com/iTunes and it will take you right to the correct page on iTunes. If you want to get mentioned on this podcast or even have comments within the next episode, please leave us your voicemail at ipfridays.com/voicemail. You have been listening to an episode of IP Fridays. The views expressed by the participants of this program are their own and do not represent the views of, nor are they endorsed by their respective law firms. None of the content should be considered legal advice. The IP Fridays podcast should not be construed as legal advice or legal opinion on any specific facts or circumstances. The contents of this podcast are intended for general informational purposes only, and you are urged to consult your own lawyer on any specific legal questions. As always, consult a lawyer or patent or trademark attorney. Copyright 2014, all rights reserved.